What's up, guys? Welcome to the Strike Industries booth 2024. I've got Cody here from FPC, General Counsel. Cody, could you please introduce yourself?
Absolutely. I'm Cody Wisniewski. I'm Vice President and General Counsel with FPC Action Foundation here at SHOT Show with Strike Industries.
Thank you for coming. Real quick question. What's the difference between Firearms Policy Coalition and Firearms Policy Action Foundation?
So, Firearms Policy Coalition and FPC Action Foundation, we're related sister companies.
Gotcha.
We work together. We have a shared mission fighting for maximal human liberty. Basically, there's some organizational differences, that's about it. But from FPC Action Foundation, I work really closely with FPC. I manage FPC's litigation docket. We oversee all of the cases that FPC is working. Sometimes I even jump in and represent FPC myself because I am an attorney.
Gotcha.
I have been doing Second Amendment litigation for most of my career.
That makes sense. Well, speaking of cases, how many cases does FPC actually have ongoing right now?
Yeah, so FPC has over 55 active cases across the country.
55?
Yeah, so everywhere from California to New York, Texas to Washington, everywhere in between.
Wow. Okay. Well, you might be wondering, why is this important person at the Strike Industries booth this year? The reason is, well, last holiday we ran a promotion together where for every stabilizer / stock / brace we sold, we donated one free membership to FPC. And Cody, what would you say a new membership is about these days?
Yeah, so memberships run anywhere from like $30 to $35, depending on if there's a promotion ongoing.
Sure.
Getting all of those members to come and join FPC was an absolute huge win, and we were super thankful that Strike Industries was willing to partner with us to do it.
Of course, and of course the amount wasn't massive, so we don't have like a fancy big check to present or anything. But we're just really glad that you're here. We had an opportunity to do a small contribution to the 2A community and also to FPC for all the great legal work that you guys do for us.
Yeah, thank you. And I mean, it's everything matters. We're all donor funded, right? We're funded completely by members, by mostly small donors, people who believe in our mission. So it's something that we kind of make a commitment to the member for at FPC. So you'll even see at FPC, right, we only have annual memberships. And that's very intentional. The idea is that our members are closely connected with us and are following along and seeing what FPC is doing. We don't want people to just, throw a lump sum, be a lifetime member, and then not, we want to re-earn that membership every year.
Re-engage.
Yeah, exactly. And so it's huge. And we're not getting multi-million-dollar donations from big, companies. So
Sure.
anything that we can get, anything that we can use to fund lawsuits is huge. Our members, our plaintiffs in our cases, our co-plaintiffs, they aren't paying for legal fees, right? Everything that we do, we provide pro bono. And that's because lawsuits can be insanely expensive.
Of course.
I've in my previous capacity, saw a lawsuit that resolved after about 10 years. And if you added up the legal bills, it cost over $1 million to litigate that lawsuit against the government. And so it's something that's out of reach for most people.
Yes.
And it dissuades a lot of people from being able to fight for their rights.
It's terrifying.
And so that's why we exist. We exist so that people can come in, people can fight for their rights, they can represent, their fellow people in their communities and in their states and in their country, and not have that barrier to entry that attorneys are expensive.
For sure. I love that you guys don't do lifetime memberships. I think that's a great model. It's a great way to just tell the community that, hey, this is what we're all about, and we're going to show you every single year. But also thank you guys for buying so many FSA dual folders, and pretty soon you guys will be able to buy the FSA dual stabilizer on its own, because you guys told us that we're tired of buying stabilizers, having these stock ends for our folder, not being able to use it out of fear for their compliance or legality, or whether they're going to be okay with the law or not. Because every state is very different.
Yeah.
Right?
Yeah, and that's one of those problems you run into, right? Not only are states different with this pistol brace rule that we've been talking about, we've been working on, it's just injected so much uncertainty. But,
yes.
But that's the point, right? That's what they want.
The ambiguity.
They want ambiguity. They don't want people to be able to understand what's going on, because if they make it uncertain, people are less likely to exercise their rights. And then that's how the gun control movement wins anyway. If they can get people just to stop doing things, then it's a roundabout way of achieving their goal.
Yeah, I've seen that a lot. In our side of the industry, when we're doing B2B work, a lot of companies will say, hey, because there's XYZ litigation or bills in a house or state legislature, we don't feel comfortable, shipping this product category to you. A lot of customers can't even get the products that they want. They're forced to, get it in other ways, right?
Yeah.
And if we can't, obviously, everyone needs to consult their own attorney. You can't give legal advice right now.
Correct.
But if we talk about it from a more cultural standpoint, what would you say would be a good method of fighting back per se? There's a term that comes to mind for me. It's common use. Is there anything like that that comes to mind that would be a good focal point for the community to hone in on to further push our agenda in the 2A community?
Yeah, for sure. I think there's two things. One, I think culture is really important, and people undervalue how important that side of it is. Right, so Andrew Breitbart famously said that politics is downstream of culture, but courts are downstream of politics. Judges, while not politicians themselves, are appointed by politicians, are people that are participating in the culture, and they're seeing the shift also. So if culture doesn't move, then we can't make certain arguments in the courtroom. So I think of something like when you're talking about braced pistols, or when you're talking about something like SBRs or body armor, those are things that are popular now, right? You couldn't have said that 15 years ago.
Yeah.
It wasn't part of the culture. And so if you were in a courtroom, not only was it harder to make the argument because, some things, not those things have been in common use forever, but, there are things that aren't always in common use. But it's one of those, that's the other side of it of, it's just not being talked about in the community, right? But if it's being talked about, if those things are, if that right is being exercised in that way, then it's more likely that the judge is going to know what's going on, understand what's going on, see what's going on in the community. So I would say culture is really important. Another thing you touched on is language. Language is super important.
Yeah.
Common use is something that has emerged as one of the factors, a test that the Supreme Court looks to when determining whether something can be banned or not, or can be heavily regulated or not. It's not the only thing,
Of course.
right? It's not the end-all, be-all, but why you hear us talking about it so much, and some other groups talking about it so much, is because it's an automatic, like, government, do not pass go, do not collect $200 kind of thing. If something is in common use, it cannot be banned. Now, there are other tests. If it's not in common use, then there are other things that we go through. But when we're talking about, semi-automatic rifles, when we're talking about magazines, these things are objectively and obviously in common use, so
100%.
you don't need to go further. So common use is a really important term. One thing I really like to focus on is trying to understand the structure of our rights, right, and the structure of the Constitution.
Of course.
So one thing you'll notice, like anytime I'm talking, anytime I'm giving a speech, is I will never say a constitutional right, or almost never say constitutional right, and that's because you don't have a constitutional right to keep and bear arms. You have a constitutionally protected right to keep and bear arms. That right pre-exists government, pre-exists the Constitution, pre-exists the Bill of Rights. You have it by virtue of being a human being. So it isn't that right is granted to you by the Constitution. It is not a constitutional right. It's something that our founders and framers considered so dear that they explicitly protected it in the Bill of Rights.
You're talking about a mindset shift.
Absolutely.
Right? Because we're so caught up in can I do this? Can I do that? What is going to happen to me if I do this or that, or if I attach, this or that product or parts and accessories?
Yeah.
Rather, it sounds like you're saying we should be thinking instead, should the government be able to tell us we can do this or not? Should the government be able to tell you where you can or can't carry, or when you can't buy a firearm, at what age, or whether you can or cannot defend yourself in dangerous situations?
Yeah, exactly. That's exactly it. I mean, you have the right. That right is being infringed. It's being restricted. It's being regulated. Those things are all true. But that right is yours. It's not the government's to give or to hand out or to meter based on how the government feels that day.
Yeah.
It's your right. They're infringing on it, and that's why we do what we do. That's why we were so excited to do a partnership and be able to raise some money and bring some more members in.
Definitely.
Is because that's the whole point. The whole point is not to sometimes you hear people talk about expanding the right to keep and bear arms. We're not in. The right to keep and bear arms is as expanded as it can be. What we want to do is make sure that the right to keep and bear arms is restored, and that right is protected, and that right is as least infringed as we can possibly get it.
On Tuesday this week, on day 1 of SHOT Show, we had a live IG with a brief Q&A session with Cody, and some of the questions that people got to ask but we didn't get to answer, we're going to try to answer right now. So the first question, it sounds like some people might need a refresher on the pistol stabilizer proposed ruling. Could you touch on that just a little bit? So maybe some people who didn't pay attention the first time around, they could get the lowdown?
Yeah, so our case is called Mock v. Garland. It's in Texas. And in that case, we got an injunction from the Fifth Circuit that was later reconfirmed by the district court. And that injunction basically said that the government was prohibited from enforcing the rule against our individual plaintiffs, our corporate client in that case, Maximum Defense and its downstream customers, and FPC and its members. And so we've got that injunction in place. After that also, there's several cases challenging this rule. There was another case in Texas where the judge basically issued a stay against enforcement of the rule broadly. So that's where everything stands right now. As you mentioned before, I'm a lawyer. I can't give legal advice. I can't
read the documents yourself. They're all on FPC's website.
Yeah, exactly. Yeah. So you can go to firearmspolicy.org. You can go to the legal action tab. You can go to the mock case. You can read the order yourself. You could go on our Twitter. You can go on our Instagram. You'll see we've got screenshots of our order, of the other orders. We've got the quote. Read it for yourself. If you're still uncomfortable, talk to an attorney. But the order's pretty plain, pretty clear.
Pretty plain and clear, but form your own opinion.
So, I know that was something that came out around that area. So what we want to make sure that we're doing too is, not putting anybody in a situation or not putting anybody in harm's risk. Yeah. Especially when, we're living in a day and age now where the ATF has been weaponized.
Yes,
right?
Definitely.
It's not like it used to be 10, 15 years ago when, the ATF was still a problem 10, 15 years ago, don't get me wrong.
Just in a different way. Right?
Yeah, it was a lot more benign.
Yeah, it was just flip-flopping on guidance letters and things like that, but now it's all about the proposed rulings.
Yeah.
The ones that come to mind, and we talked about the pistol brace, there was one about 80% lowers, which sounds like you guys are doing great in the Vanderstock case.
Yeah, that's been a big one.
Yeah, can you talk about that a little bit?
Yeah, absolutely. So, Vanderstock is in a kind of an odd place. It was a great case. We got injunctions all the way through the case.
Yes.
Preliminary injunctions, meaning that the injunction spans the length of the case until you get a final decision. That's what a preliminary injunction is. And so we had those in place. Our individuals were covered. Our clients were all covered. That was as far as the court would go in that case. But when you're talking about 80s versus pistol braces, it's a lot different because if an 80 is not a firearm, which it isn't, then it can be shipped direct to consumer.
Correct.
So, the relief there was great. Then we won the case at the district court, which is awesome, and was a huge victory.
Big win.
And then the government appealed, and the court stayed our win. The problem is with that win, the existing injunction, because it's preliminary, dissolves. But it was okay because we had final relief until the court stayed the final relief.
The appellate court?
The appellate court. Well, yeah. So, and then this was the case that went all the way up to the Supreme Court that people were watching, and that the Supreme Court kept the stay in place. So it's in this really weird spot right now. We're pushing the case forward as quickly as we can so that we can get final relief, but the government's delaying as much as they can.
Gotcha.
Right? They're not interested in moving quickly. They're not interested in pushing the deadlines. They're not interested in, because at the end of the day, they don't want people to do this, right? Yeah. They lost their case.
Yep.
They already lost, and now they're just dragging it out to try and let the rule sit in this legal limbo, stay in place, even though a federal court has already ruled that it's unlawful.
I think that's really terrible, because on one hand, you have a federal agency that is supposed to be helping give guidance so that we know what to do in this industry, so that customers know what to do to be law-abiding citizens, and yet they're trying to criminalize us all through ambiguity, through lack of guidance, through just trying to destroy our rights.
Yeah, I mean, they've become weaponized. There's no longer, working with the industry. I mean, they've never really worked with the industry as far as I'm concerned. They've certainly never worked with the people or worked for the people. Yeah. But they're at a point now where they are, I mean, they're exploiting ambiguity. They're injecting ambiguity to try and stop people from being able to do things just because they're afraid, like we've been talking about. They're slow rolling cases where they know they've lost just to keep some, their dying grasp in place on it.
Yeah.
It's frankly, it's offensive. I mean, it's no wonder that there have been so many calls for, disbanding the ATF, getting rid of the ATF these days, because what else are you supposed to do?
Yeah.
They're not, playing in good conscience. They're not doing this for the benefit of the people. So, we've gotten to a place where they're showing their true colors.
Yeah. I feel like we're coming to a breaking point, Like, the tensions between the 2A community, the industry as a whole, and this singular government agency, I feel like it's coming to a head, and I'm really curious as to how things are going to continue to develop.
Yeah.
Is there anything at the top of your guys' radar, the forefront of your mind, for things you're looking out for in 2024 that you can share with us?
Yeah, so, we're keeping a close eye on the agencies. We're keeping a close eye on the ATF just because they have that national impact.
Yeah.
Right? It's really important that we're addressing all these state issues, and we do. We're in something like 17 different states with lawsuits. And that's important. And those state lawsuits in federal court can cover not just that state, but the circuit, right? The federal circuit court that is in charge of a group of states, right? So, that's really important to do as well, to make sure that, we're bringing those cases. But these ATF issues have national impact immediately.
Yes.
And that's really important. So one thing that we've watched out for, that we dealt with right at the end of last year, was this engaged in the business rule.
What is that?
So it was a proposed rule that basically sought to exploit the, Bipartisan Safer Communities Act.
Ooh.
That was passed.
Don't like the sound of that.
Yeah, in a bipartisan manner not too long ago. And functionally what the rule attempts to do is make it ambiguous as to what constitutes being engaged in the business.
I see. I know what you're talking about.
For purpose of...
Are you talking about the private party transfers?
Private party transfers.
Oh,
yep,
man. Yeah, so if I try to sell, if we live in the same state, I'm trying to sell you a firearm. If I sell you one too many, all of a sudden they want to make me an FFL?
Yeah. Not even necessarily one too many.
Okay.
There are factors so this is just a proposed rule, right? We don't have a final rule yet.
Okay.
So that's where it stands right now. But there were so many factors. It wasn't just, how many guns you sold. It was how much did you sell them for? What did you sell them with? If you sell it with the original box and manuals, then that ATF says that they should consider in whether or not you should be an FFL. Also, under the proposed rule, they're not going to force you to become an FFL. Once you do the transaction, they're going to charge you for being engaged in the business of firearm sales without a license. So it's not even like, hey, we saw that you're doing these private sales, you need to go get an FFL. It's, hey, we saw that you're doing these private sales, we're going to throw you into a federal prison for 10 years.
That escalated very quickly.
So that's something that we're watching for. That proposed rule came out at the end of the year. People kind of have followed along with these. So now, it used to be when we talked about like Administrative Procedure Act stuff, APA stuff, which is what this is all under, that it was really confusing, and it still is. But I think now that people have seen it happen, they kind of understand. So you have the proposed rule, and then you have a comment period.
Yep.
And then the comment period closes, and then the agency considers the comments, and then
the final ruling.
Well, so technically they can withdraw the rule if
Really?
they wanted to.
Okay.
Yeah. Funny how that never happens in our industry.
Bummer.
Yeah, but they could withdraw the rule, or then they issue the final rule. And then normally there's a period of time before it goes effective. Obviously, in the in the pistol brace instance, it was a little different, which was illegal, but they did it anyway. So we're really watching out for that this year.
Okay.
A lot of states are getting squirrely, so we're keeping our eyes on a lot of states this year.
Yeah.
But so I would watch out for some action coming in some different states for sure.
By squirrely, are you referring to how states are copying sort of like the California blueprint, where there's just like a menu of what makes an assault weapon, and having every state's own version of an assault weapons ban?
Yeah, yeah. And it's not just, assault weapons, it's magazines, it's carry restrictions, it's all these things, right? People are following, the California, the New York models, or some states are trying to do that. But what I do want to say, though, is that it's not all doom and gloom, right? Like, I try and, impart some optimism.
Yes.
So
there's hope.
There is hope. There is hope. Just Every ATF rule, every major ATF rule that's been published in the last 6 years has been enjoined, right? So you had the bump stock rule, which was defeated at the Fifth Circuit en banc,
Yes.
and is now up at the Supreme Court. That case is being heard by the Supreme Court. We will have an opinion from the Supreme Court about that bump stock rule, which will be huge.
Yeah.
And it'll have a lot of impact on everything downstream.
Huge precedent.
We got the framer receiver rule enjoined, and then we won that case. Now we just need to get it moving so we can get the final relief. And in pistol braces, we got our preliminary injunction, and then there was the stay issued by the other court. So every ATF rule issued in the last, I think that's about 6 years, right? Bump stocks was during the Trump presidency.
Pretty much none of them came to pass the way they wanted.
No.
Right?
So there's some optimism there.
Yeah.
Also, for those that are paying attention, right, when Bruin came out in 2020, it really reiterated what Heller said.
Supreme Court ruling.
Supreme Court ruling, yes. So one of the major Supreme Court cases. But what was really important with Bruin is not just that it reiterated what Heller had said, the other major Supreme Court case from 2008,
Yes.
but that it specifically told circuit courts to actually follow what the Supreme Court was saying and actually look to the original public meaning of the Second Amendment, actually look to text and history, which is the test that the Supreme Court employs. So since then, we've had a monumental series of wins. What we know is we were doing it right all along. We were making the right arguments all along, but the courts were applying the wrong test. So now that the courts are applying the right test, we've gotten injunctions in California, New York, New Jersey, all sorts of states, Delaware, everywhere.
We've seen federal judges overturn bad cases, even ones that were appointed by Biden's administration.
Yeah. We have had more wins in the last year and a half since Bruin was decided than we had in, the 14 years between Heller and Bruin.
That's huge.
It's massive. So there is a huge turn. We're finally actually looking to the true constitutional structure. We're actually looking to our history and what the founders and framers, meant when they wrote those words on paper and what the people understood those words to mean when they ratified the Second Amendment in 1791. So there is optimism. There is reason to be happy. It's not all doom and gloom. Yeah. So I just want to make sure that people know that.
Yeah, I'm glad you mentioned that. The last couple of questions I have for you come from our IG Live on Tuesday.
Yeah.
So some people are asking about some California-related issues, and I think these are great questions because people in California, the layman, may not understand everything we just talked about, the context, the historical precedents, and the legal precedents from the past 2 decades now. Right? So some people might be wondering, okay, with everything that's come to pass in California, how they've been setting this sort of trend for the other side of the aisle to create anti-gun laws, anti-2A laws. I think there's this idea in California where things are getting better, but they're being masked as getting better, where things are happening on the side that are still hurting and are a detriment to the community. For example, the California handgun roster, where there is a detail that not everyone really talks about, a dirty little detail where for every new handgun that's added, 3 are taken off. And it used to be that the Cal DOJ had to list what was removed from the list, and apparently recently I heard they no longer issue that information.
Yeah, so we have an active lawsuit in California challenging the roster. So it's something that we're working on for sure, and something that we're really hopeful about. The Ninth Circuit is what the Ninth Circuit people know what it is.
It's tough.
Yeah. So, so be it. But this roster case is really egregious. I mean, and that's when it comes to this historical test, right? If the government bears the burden, if the government can't point to a historical analog, something that, was sufficiently similar surrounding the founding era, then their law is unconstitutional. And California can't do anything like that here. And so, it's pretty clear in this case, so we're really hopeful that, the Ninth Circuit will even see that, but it is, it is tough. There's a lot going in California, and these legislatures don't care, right? They'll pass any law that they want, and then it takes 5 to 10 years to fight it in court sometimes. So, I definitely understand that there's a lot of things coming, so we're always challenging, the things that we can, the things that, present the best case. We have to be very strategic about what cases we bring, so that's really important also. But the other kind of part of that is, don't forget that we kind of have lost access to a lot of these rights in an incremental way.
Yeah.
Right? It wasn't one law passed one year that just issued everything.
Yeah.
And so walking it back is also going to be incremental in some senses, right? Like, we're going to win carry cases. We're going to win, these so-called assault weapon cases. We're going to win these magazine cases, but it's going to be that kind of incremental receding, just as it was an incremental increase.
Just to remind me, what's the name of the case regarding the California handgun roster?
That's called Rena v. Bonta. So if you go, for all our cases, but for Rena included, if you go to firearmspolicy.org, click on the Legal Action tab, you'll see all of our cases listed.
Full list.
Yeah. You'll see, and if you click on the case, you can see all of the major filings in the case. You can go and read them. Everything that we do is out in the open, right? Everything we do is public information. What we're saying, what I'm saying on here is what I'm arguing in courtrooms.
Perfect.
Maybe with some, fancy legal terms, but we stick to the mission, and we don't, sell anything out just to get a court win. We're looking at the long game. So you can go to our website, you can check us. You can go to our website, you can look at the cases, you can read the filings, you can see it yourself.
They will respond to you on Twitter, so watch out.
We will.
Yeah. Our last question is still about California. So be that California is sort of an anti-2A trendsetter.
Yeah.
Do you think that the legal setting, the legal playing field in California is sort of a proving grounds for 2A precedents, so that if FPC and other 2A advocacy groups have wins in California, maybe that'll send a message to the other states to say, hey, you can't play around because you will get shut down.
Yeah, I mean, it's definitely a signal, right? It's one of those things where if you can win in California, you can win anywhere, kind of thing. So it is really important, and people look to California like that. People look to New York like that too, because of the cases coming out of New York.
Yeah.
So those are really big, but it's not all just California too, right? We make sure that we have cases across the country in all these different states, because it's important to get those wins in California. The Ninth Circuit is also the largest circuit in the country, covers the most people in the country, so that's hugely important. But we're not forgetting about people in other states, right? We've got an active lawsuit in New Mexico right now. We've got active lawsuits.
A lot of drama there.
In Delaware. We've got stuff in Washington, in Oregon. Those are Ninth Circuit also, but not California.
Right.
So we do have a lot of action in California because California is passing so many laws, and because it is a sort of proving ground. But we have cases spread across the country, across the circuits, on all sorts of issues.
Gotcha. Cody, thank you so much for joining us at the Strike Industries
thank you
booth.
for having
It's been
me.
an absolute pleasure to have you here this year at SHOT Show 2024. So guys, if you don't have an FPC membership yet, we strongly encourage it. And if it's not FPC, find another 2A legal advocacy group that you can get passionate about. See if they're active in your local area, your state of residency, and find what issues in the 2A space that you're passionate about and interested in. Because it's up to people like us to stand up for our rights, to make sure that they don't disappear for this generation and the following generations.
Yeah, absolutely. I think that's so important. It's just important that people are involved, that people are fighting. What matters at the end of the day is that we win. What matters at the end of the day is that these laws go away. And, of course, we love, people joining FPC, people coming to FPC Action Foundation, seeing, what we're doing on that side and seeing that portfolio as well. And we're really appreciative of Strike Industries for putting on this promo, for partnering with us, and not only getting some members at FPC and showing people that way, but also just having these conversations, talking about these things, and understanding the importance of the right, not just the market, the right. And I think that's hugely important. We really appreciate that.
100%. Well, thank you so much for your time.
Thank you.
It's an absolute pleasure. See you guys.